Welcome to Better HR in 10 Minutes, where we take a question for HR and in 10 minutes or less, we discuss it from the point of view of a trainer and an employment law attorney. I'm the trainer, I'm Rodney Klein.
And I'm the employment attorney. I'm Sarah Glasser.
So, in this session, Sarah, I've been getting a lot of questions lately, especially with everything that's been going on, about discrimination against individuals because they're gay or transgender. And so I thought it might be helpful in this discussion if we just kind of started it by going back to the beginning, which is the Bostock case, and kind of going through that so that we can kind of understand what the law says about discrimination there. So why don't you kick us off?
Yeah, absolutely. And in fact, if we go back to the beginning, perhaps we could go all the way back to the beginning to 1963 when Title VII was being written, 1964 when it was passed. And Rodney, I know you know the language that is in the statute, but if for the folks who are watching us who have not, read Title VII recently, tell them what it says.
Well, it just says you can't discriminate against someone because of their on the job, because of their race, color, religion, sex, or national origin.
Okay, so because of their sex.
Because of.
And in 1964, I think we can all imagine what the legislators were thinking of when they said you can't discriminate against someone based on their sex.
Mhm.
And in 2020, the Bostock decision came out, and we all were talking about it tons then. But in fact, that's not the first time that the Supreme Court has weighed in on what Title VII means when it says because of sex. And in fact, that definition or that phrase has been reviewed and, in my opinion, broadened
Right.
over the years, um, several times over, including in the 80s and the 90s when we were talking about what it means to act in the way that your gender or your sex stereotypically would have acted. And so Bostock is just another Supreme Court case where the Supreme Court is defining what we mean when we say discrimination based on sex. And in that particular case, the plaintiffs in Bostock happened to be gay and transgender. But what the court was really looking at was what does that term mean based on sex? And what they did in their assessment is they said, well, and this is just one of the examples because there were
Mhm.
several plaintiffs, but they said, well, if you are a man and your employer fires you because you are dating or married to another man, but they would not fire a woman for being married to a man, then they have fired you for one reason and one reason only, and that is the fact that you are a man and not a woman. And according to the court, that is discrimination based on sex, not discrimination based on sexual orientation, but based on sex, because it has to do with this side. Are you a man or are you a woman? And I think that maybe you have the same maybe you have the same experience that folks did not necessarily take that away from Bostock when we were first talking about it a few years ago.
Yeah, I think that the kind of the impression I got from people is that when Bostock came out, that there was kind of this idea that, well, the Supreme Court just kind of created these two new bases. And I think in a practical sense they did. But the key point was not that uh, sexual orientation and gender identity is protected. It's that sex is protected. In fact, if you go back and read Bostock, it says that this ruling rests entirely on Title VII's recognition of two biological sexes. How does that happen? Well, Title VII works on a mixed motive theory, right? So, in other words, if one of the determining factors in the discrimination is, let's say, race, then that would make the whole thing illegal. So, if I'm an employer and I fire somebody for 5 reasons, and one of those reasons happens to be because of their race, well, that would make it illegal. So, if we look at something like gender identity or somebody that's transgender, then sex is actually kind of baked into the definition. In other words, a person is transgender is an individual who is either identifying with or presenting as a gender that's different or inconsistent with their biological sex. And there you go. That's the connection. You can't even, if we talk about somebody that's being discriminated against because they're gay, you can't even define a person's sexual orientation without referencing their sex, their biological sex. So that's what the Supreme Court was saying. And I think that that was the important point. People get and rightfully so, kind of acknowledging the practical side of it that makes gender identity and sexual orientation kind of covered. But I think the bigger legal implication of Bostock was that anything is covered if sex is at all implicated.
And we saw cases leading up to that too. If you start
Right.
talking about firing me because I don't wear makeup or I don't like to wear high heels or something like that, which is an older case, but if you start talking about that, I mean that is intrinsically related to my biological sex and the way that I present myself.
Yeah, you can go back even further. I mean, sexual harassment, right? All of us equate sexual harassment with sex discrimination, but you know what? It wasn't always guaranteed that way. Back in the 70s, um, women would file discrimination complaints on sexual harassment, and employers would actually write back and say, well, yeah, I chased Jane around my desk, but I didn't chase Jane around my desk because she's a woman. How do I know that? I didn't chase all the women around my desk. Nope. I chased Jane around my desk because I wanted to have sex with her, which last time I looked, being the object of sexual desire is not covered under Title VII. This went to the Supreme Court, and the Supreme Court was like, if we're really serious about addressing sex, this we have to address this. In other words, not every woman or every man is sexually harassed, but those men and women who are being targeted because of their biological sex. And so this goes all the way back. And as you indicated, there's several times throughout legislative history where the Supreme Court has kind of expanded that version to make sure that things that are implicated by sex are covered.
Yeah. So what's our takeaway for folks? Number one, which I think is kind of the question that I'm seeing swirling around is what is Bostock still good law? And the answer is a resounding yes. We have seen over the last, gosh, it's 5 years now. We've seen over the last 5 years a number of different cases that are kind of coming up through the lower courts that are looking at how do we interpret some of the things that Bostock left open,
Right.
or trying to chip away at Bostock in a in a more in kind of like a dedicated way. But at the end of the day, that's Supreme Court precedent that has interpreted Title VII, and even if the political waves are shifting in a different direction, or we're seeing agencies enforce things in a different way, at the end of the day, the law is still the law.
Yeah, I think the thing that's kind of sad about it is it's like people kind of pick winners and losers here on sex discrimination cases. And the law really wasn't kind of set up that way. It was set up to just address biological sex. And even though there are things like you mentioned around the periphery that have not been settled by the court, what was unambiguous in the court's ruling was that this is protected. So there's a lot more to talk about, which we will. And so, but I think this does it for this session. So I hope this was of help to you and have a great rest of your day.